All right.
Thank you. Welcome back.
Thank you so much. Thank you so much. How's everybody doing this morning?
Good.
Okay. Am I in the frame? Cool. All right. Where is everybody? Is everybody out like selling houses or something? They're away? Okay. Well, it's good to have you guys here. I have lots of great news for you. I'm just kidding. There's no good news. I'm just kidding about that too. So I will start with the good news and then we'll get to the usual bad news. The good news is that a few Tuesdays ago, we had an amazing, amazing night. And I'm not talking about the presidential election. I'm talking about the state propositions. The entire real estate industry was pretty much on the line. And I don't know if people really understood that. But the entire industry was on the line. There was Proposition 33, which you guys might have heard of. And there was another one called Proposition 34, which was tied to that. Just so you guys understand how it works here in California and its effect on the local governmental bodies. The local governmental bodies, if left to their own devices, would have rampant rent control. They would put rent control on single-family homes. They would get rid of what's called vacancy decontrol. That means the concept that when someone moves out of an apartment or an otherwise rent-controlled property, when they leave and you rent it to a new person, you get to set the rent to the market, right? Now that's just kind of something everyone relies on as if it's common sense. That's just always going to be the case. That's always been the case. It's not. In New York, they have actual vacancy, rent stabilization. That means the rent stays the same from tenant to tenant. And when they expanded that, they literally destroyed 30 to 40% of the value of buildings overnight. It was a disaster, unmitigated disaster, right? And that's what this AIDS Foundation, Michael Weinstein, was trying to do here in California. The way that he had to contest that is he had to try and get rid of this law that we have, which is amazing, called Costa-Hawkins. It was passed in 1995, right? Back in the day when we had a relatively sane legislature. And they said, you know what, we don't like it that local cities and counties could just do whatever the heck they feel like that day when it comes to rent control. We're going to put some controls on it. Well, number one, we're going to say you're not allowed to get rid of vacancy decontrol. Once the tenants leave a unit, we don't care if your unit's rent control, the landlord gets to set the rent again. Right? And that's very, very, very important because that is how multifamily and even single-family homes that are used for rental purposes are valued. That's how they are assessed by a bank in terms of how much money a bank or a lender is willing to give for that property. And a lot of that is based on pro formas. A lot of that is based on assumptions about natural attrition, how many people generally will just move out of the building, and how the value of the building will go up because the amount of rent that it collects will go up. That's what was at stake because this guy, Michael Weinstein, who is the CEO of the AIDS Foundation and gets involved in stuff that has nothing to do with his business, right? He keeps on trying to get rid of this Costa-Hawkins. And for the third time, thankfully, it failed. It failed big time. Prop 33 did not win a single county in the entire state of California, right? Which was an amazing result, a miraculous result, because everyone was terrified it would be close. Now, there's another proposition called Prop 34, right, which aimed to stifle Michael's ability to keep doing this every 2 years. And it said, if you are in the health business, and if you are one of these companies that gets special treatment because you're a nonprofit, you're not allowed to take that money and go out and spend it on things that have nothing to do with your business, such as politics, such as housing politics, such as housing policy, because that literally has nothing to do with what he does. The AIDS Foundation gets a special boost. How does he have all this money to spend? right? He's able to buy AIDS medication on the cheap using federal money, right? And then still bill the insurance full price for it, as if he's a regular medical provider.
But is that allowed?
Yeah, that's allowed. That's allowed. But then there were no restrictions. Why? I don't know. That's a different story. But there were no restrictions on what he could do with his money. So he could go out and just get involved in whatever he wanted to get involved with, right? Prop 34 put limits on what he could do with that money in California now. So now not only did he lose the battle, he's now been stifled to be able to keep doing it again. And that pretty much means that Costa-Hawkins, at least for the time being, as a matter that can be voted on by voters, is pretty much safe. Because no one else is going to be crazy enough to keep trying to put this on the ballot after it's failed 3 times, and failed miserably 3 times, right? So whether everyone knows it or not, it's kind of like when the FBI stops a terrorist act, everyone doesn't really know about it because nothing happened, right? So it's on the news for like 3 minutes. For people who don't know, the entire real estate industry was saved that night. It was a big, big, big deal. So that part of it is very, very good news. And even if you're in the business of selling single-family homes, it still affects you, because if they were to come and put rent control on single-family homes, all the people who you are helping buy, who are thinking, okay, I'm gonna buy this home as an investment, I'm gonna live in it for 3-4 years, and then I want to rent it out. Well, they might not see that as a good investment anymore had this passed. And so thankfully it's safe. Because another one of the things that Costa-Hawkins guarantees is no rent control on single-family homes, right? So that part is the good news. What's some of the not so great news? Some of the not so great news, again, if you are dealing with people who are renting, is the city of Los Angeles decided to expand their anti-tenant harassment ordinance. Now, what is the anti-tenant harassment ordinance? It's a list of things that if you do in, quote, bad faith, right, that are considered harassment. And most of them have nothing to do with harassment, right? And if you do those things, not only can you use the harassment as a defense to a UD, unlawful detainer, or an eviction, right? You can also, the attorneys can also file affirmative claims for those alleged harassments. And there's an attorney's fees clause. So if they win $5,000, they can get attorney's fees. And the attorney's fees may be 10, 15, 20, 50 times what the underlying damages are. So what they're trying to do, and they're not only adamant about it, they're open about it. They're trying to encourage more private attorneys to take these cases and privately prosecute alleged harassments. Now, what are these harassments? Well, if you are in bad faith not fixing something, if you are in bad faith not fixing it according to industry standards, right? And then, there's a whole list of dumb stuff. Also, it says if you approach your tenant with an offer to have them vacate, and it doesn't even put any limits on it, it just says it like that, right? Now, in this ordinance, it says that's harassment. There's a whole other ordinance that tells you what the rules are for doing that. It's called the Cash for Keys Ordinance. It's a buyout notice. There's a notice that the city puts out, and it says this is the notice you have to give to tenants when you want to make them a buyout offer. So they're pretty much saying this is allowed and this is how you do it over here. And then it says if you do it over here, right, that's harassment. It makes absolutely no sense, because over here it's, quote, bad faith. What is bad faith? It's if you do it intentionally, recklessly, or grossly negligently. How are you supposed to grossly negligently offer a buyout? That makes no sense. And if you're offering a buyout, of course you're doing it intentionally, right? So by that definition, every buyout offer is in bad faith. So either you could be following the rules and still not following the rules. It's complete nonsense. Yeah.
Well, not that I'm advocating for tenants' rights per se, but I think part of the problem is that a lot of the tenants don't know what their rights are, whereas the landlord do.
No, they don't.
Well, they should, obviously. But I think that's probably where some of the harassment comes in is,
There was a judge who recently commented that landlord-tenant law in California has become so complicated
that's very true.
and so highly regulated that it's one of the most regulated businesses in the entire state, right? That's compared to things like nursing homes and nuclear power, right? You know what there's not? There's no mom and pop nuclear power plant operator. That doesn't exist, right? And there's barely any more mom and pop nursing home operators. And the ones that still exist, mom and pops, have no clue what they're doing, right? You should still be able to be a mom and pop apartment owner. It's not supposed to be something where you need me on a daily basis on the phone just to ask, am I allowed to do this? Am I not allowed to do this? Where do I post this notice? Where do I file this? Where do I serve this? Where do I pay this? It's gotten insane.
But is everything still in the Rent Stabilization Board's websites per jurisdiction?
Well, I mean, you have to know if your property is rent stabilized or not.
Put in your address, but I'm just saying is the.
It's not that simple. Yeah, it's really not that simple. A lot of people, for example, let's say you guys sell someone a house, single family home, right? Down the street, 6 bedrooms. It's a single family home, right? 1 kitchen, 6 bedrooms. Family lives there, move out, owner decides, I'm going to start renting, right? He doesn't rent it to one person, he rents each of the rooms individually. Say again?
That's not allowed though, correct?
Sure it is. It's allowed, but is it still a single family home? The owner doesn't know. That's called a boarding house. What it is, it's called a boarding house. And technically, if the house was built before 78, you just turned your single family home into multi-tenant housing. Do they know that? Do they go into the LAMC codes and understand all of this? No. And I've had a lot of calls from people who think they're doing something regular and normal, and they don't understand they've gotten themselves into this quagmire. By the way, in that particular example, the problem is that because it's a single family home on Zemus, if you actually want to register it, LAHD won't let you. And then if you try to evict someone from there, because you're not registered with LAHD and it's technically rent control, you can't evict someone because you didn't follow the LAHD rules. That happened to one of my clients. And he had to beg LAHD to let him register it. And they were saying no, and the court was saying it's rent control, and the LAHD was saying it's a single family home, and he was stuck in the middle. And he couldn't do anything. That's a real thing. That's the problem with this overregulation. But anyway, yeah, go ahead.
Just to clarify, just making a statement. So in other words, in order to protect the tenants from the evil giant corporations who are the landlords, they're forcing the mom and pops out, so the only people who can rent are the evil giant corporations.
Oh, it's much worse than that. It's much worse than that. In order to get rid of the mom and pops and the corporations, what they were trying to do, and again, this is why the whole Prop 33, Prop 34 thing was such a big deal, is they're trying to, either consciously or subconsciously, devalue the buildings to such a degree where the only buyer on left is the government. And then the government comes in, buys all the apartment buildings, voila, you have nationalized housing in the state of California.
On the cheap.
On the cheap, exactly. They'll take it on 25 cents on the dollar when they've run everyone out of the state. Yeah.
What is the threshold to take you from a mom and pop to a corporation? How many properties do you have to own?
One.
One? Wow.
I mean, there's
If I own one property and I rent it out, I'm not a mom and pop?
no.
Don't the laws
Oh,
say
do you mean to get the discount when you're evicting somebody?
Well, aren't the laws different if you own multiple rental properties versus if I just own like one?
No.
I read that.
No.
House of Hopkins or the RSO or somewhere.
No. That's the problem. The laws are identical. The only thing you get if you own less than 4 units,
Less than 4.
Correct.
you get to pay a little less when you are evicting somebody
So what if
for a no fault.
you own 4 or more, but you own them all in different LLCs? Are you then one one person or are you 4 people?
It's not 100% clear. But again, the laws other than that difference of how much money you have to pay when you're doing a no-fault eviction, there is absolutely no difference between owning 1 unit and owning 10,000. No different whatsoever. Right? So you have to know and follow all the same rules as every big owner out there that you've ever heard of. Yeah.
Is there a difference with regards to rent control? Let's say I have a townhome and I own 4 properties as opposed to owning 2 properties. Is there a difference how it affects my townhome with regards to rent control or eviction
Nope.
control?
Nope.
So that's a myth.
I'm not sure where that got started, but fundamentally, no. There's really no difference. Whether your property is rent control is largely a function of what kind of property it is and how old it is. And to a certain degree, depending on those two things, how you're using it. Like I gave you an example of the single family home. A lot of people think, oh, okay, I'll buy a single family home. I'm not going to rent out the rooms, but I have a back house, right? And I'll rent out the front to one person and the back to a different person. When I was using it, it was a single family home. The back was my studio or something, right? That's still a single family home. The second you rent it to 2 people, that's called a duplex, right? And you might have half rent control, half not. If the back house is an ADU that you got legal, you permitted after October 1st of 1978, the back house is not going to be rent control. But the front house, because it's probably older than October 1st, 1978, when you start renting it, now it is rent
Isn't
control.
rent control about like the areas that, I'm sorry, I feel like I'm an idiot or something, but isn't rent control just the areas that you're in? Santa Monica's rent control.
Nope.
Certain areas of the city of Los Angeles are rent control.
No.
Long Beach is not rent control. I mean, what is?
Nope.
Not by jurisdiction?
Nope, not at all. And you're not an idiot. That's the whole thing. That's the problem, is that every single jurisdiction has its own rules. That date that I just quoted to you, October 1st, 1978, that only applies in the city of LA.
Right, I've dealt with investors getting people out and what we have to do and how much they have to pay per area that they're in.
That changes per area. That changes per area. So the amount of money that you have to pay in relocation. So say you're doing what's called a no-fault eviction, right? Usually with investors, they're not doing what's called landlord occupancies. They're not trying to move in themselves. They're trying to just get everybody out to demolish something and build something new. If you're trying to demolish a rent control property, you would use something called the Ellis Act, right? You guys ever heard of the Ellis Act? All right. So it's basically a state law that says anytime you want, you're allowed to demolish the building. You have to follow certain rules, certain protocols, give everyone a certain amount of time, give everyone a certain amount of money. The time that you have to give them is dictated by state law. The amount of money you have to give them is dictated by each city individually, right? So the amount of money you have to give in Santa Monica is different than in West Hollywood, is different than in LA, right? Is different in Inglewood, Culver City, and any other place that has rent control. And the number of cities that have rent control are also increasing. But in terms of the dates of when a property is rent control or not, so for example, in the city of LA, it goes by October 1st, 1978. Why? Because according to Costa-Hawkins, you cannot put properties under local rent control anytime after either the date that your city's rent control started or February 1st, 1995. So if your rent control started after February 1st, 1995, February 1st, 1995 is the latest you can go, right? But if your rent control started before that, that's your date. So it's the earlier of the two. So in West Hollywood, the date is in 1984. In unincorporated LA County, it's February 1st, 1995, because their rent control only got put in, I think, about 6 years ago, right? So you could have one apartment building that's, let's say, built in 1990. And if it's on one side of the street in unincorporated LA County, it is definitely rent control. And if it's on the other side of the street in the city of LA, it's not LA rent control, right? So and you have to know where your property is, by the way. The mailing address is not determinative. Right? We had a guy who bought a building and he thought it was in the city of Gardena. It's not. It's in unincorporated LA County. And that means his entire plan, everything had to be changed. But on the mailing address, it says Gardena. Right? So you have to know where to look to find out where your property is, what rules apply to it. It's getting a little crazy.
It's not based only on your bill? Like 1979, nothing is rent control after that? Or could it be a possibility?
But you have to know what city you're in, because the city you're in determines what date applies to you. And remember that the city limits, are sort of just they're just there, but they're not like, it's not a big line. It's not like a big pole that separates Culver City from LA. You just have to know what the street is.
City recorder.
No, there actually is a way to check it. It's there's a website now called lavote.org, and you check by the precinct maps. You can just put in the address, and it'll tell you exactly what city you're in. That website is determinative. That will tell you.
What's the website again?
It's under lavote.org, so it's part lavote.org, and then you look in the precincts maps. I think it's /precincts maps or something like that, and you can actually check to see what city your property is in. And it's very important when you're selling a house or buying a house that you're giving your client the best and most proper information, because they think they might be buying a house in one city. Turns out they're not. Right? So, back to the LA anti-tenant harassment. That is something that they are now strengthening and making kind of stupider, but it's something that you have to just kind of take into account. I don't think it's really going to change a lot of behavior. People who were slumlords and people who were actually doing the harassment are probably just going to continue doing it. And the kinds of things that I think these attorneys are going to start trying to file frivolous claims for are things that just have to be done. You have to be able to come into the tenant's house to check, to see what kind of repairs need to be made, and then you have to come back to do the repairs, and sometimes that requires multiple entrances. The tenant might claim, oh, you're abusing the right of entry. That's one of those 16 reasons. But you have to do it. You have to do it anyway. And we're just going to unfortunately see this cottage industry built out from this law. A lot of very much like the ADA claims are. You guys know about the ADA lawsuits?
Yeah.
This legalized form of extortion? If you don't, the ADA was theoretically a good law designed to make places accessible to disabled people. Problem is, when you combine the ADA with another state law, California state law called the Unruh Act, you created this cottage industry where attorneys partner with people, or even just associations who are advocating for disabled people. They claim to go to places. They claim to have tried to visit some sort of business, right, and said that they encountered some sort of barrier to their entry. A lot of the times the barrier to their entry is the fact that the parking wasn't striped correctly, or that the slope by the handicapped space was, instead of being 1.5 inches, it was 2 inches, right? This barrier to entry. And they'll file lawsuits. They'll use the same plaintiff sometimes, hundreds, if not thousands of times, right? Who'll file claim after claim after claim after claim after claim. There's no way they actually went to all these places. And to make it worse, now they started doing lawsuits based on websites which are not sufficiently accessible to blind and visually impaired people. So there were programs that were created to help with this and make those websites accessible, and then they give you a check, and they basically put their little stamp on your website and say, hey, this website was approved and it was changed, modified in order to be accessible. They'll still sue you. And they'll say that website or that program doesn't match what the standards are. You know what the standards are? They don't exist. There are no official government standards for what it means to be accessible for the visually impaired. There's sort of some general association guidelines, but there's nothing official that says if you meet these, you're good. It doesn't exist. And so they file these ADA claims over and over and over again. They ask for just a small enough amount of money to not make it worth it to fight them. And each lawyer, we know it's like a menu. This one takes 3, this one takes 5, this one takes 7, that one takes 9. Oh, don't get hit with that one, he takes 14. And it's literally not worth it to fight them, right? The math just doesn't add up because you'll spend more fighting them than it costs to simply give them money. So it is legalized extortion. And unfortunately, that's what we're concerned will happen with the anti-tenant harassment. By the way, another fun thing that's happening to real estate agents and owners, this is the new scam. Everybody here know what Section 8 is? Okay. For those that don't know, Section 8 is a federal program that provides rental housing assistance to people, and it is administered by local housing administrations all around the country. Okay? In the state of California, they passed a law as part of the fair housing laws, fair housing discrimination laws, that says you are not allowed to discriminate against a potential renter based on source of income. What does that mean? That means you're not allowed to tell someone, I don't take Section 8. That used to be a right you have. You used to have a right to say, I either want to participate in this federal program or I don't want to participate in the federal program. Now you might ask yourself, why would I not want to participate? The checks come like clockwork. Well, because every now and then they don't. They do annual checks, Section 8, right? And if your house doesn't pass, they'll stop paying you. Even if the reason you didn't pass was the tenant's fault. Eventually, they'll just cut the tenant off and you'll have to evict them. But in between, if your house doesn't pass, even though it's the tenant's fault, they will stop paying you, the landlord. Even if there's nothing you can do about it. Even if the tenant won't let you in to do the repairs. Section 8 says, not our problem, evict them. In the meantime, we're not paying you because you didn't pass.
That can happen with any tenant.
Say again?
It can happen with any tenant.
Exactly. And it has happened and it does happen. So as a landlord, you might want to say, you know what? I don't need that nonsense. Well, that's not something you get to say anymore. Now, saying I don't rent to Section 8 people is the legal equivalent. And I want to make this clear. I'm not saying it's the moral equivalent, right? I'm saying it's the legal equivalent of saying I don't rent to black people, or I don't rent to Jews, or I don't rent to people with families. It is now the legal equivalent, right? Saying I don't rent to Section 8 is just like saying any of those things, right? How many of your clients who might be renting out a house do you think know that law? Very, very few. So lawyers got together with Section 8 people, just like the ADA stuff, and they started a new fun scam. They will start texting brokers, agents, and owners and saying, hi, I'm interested in your house. Hold on just one second. Right? Do you take Section 8? They never call, they always text. Right? And the landlord doesn't know. Sometimes the agents don't know. And they say, no, this owner doesn't want to take Section 8. Or the owner himself says, no, I don't want to take Section 8. Boom, lawsuit. Right? They'll demand $16,500. Right? I've had 4 calls and a few of these cases from the same tenant and same law firm. She filed in 1 month 15 cases. Right? She already lives somewhere. She wasn't even looking. It's a scam. Perfectly legal scam. Right? You have to be very careful. Please be very, very careful. In 2 of those, the real estate agent was the one who said the owner doesn't want to take Section 8, and the real estate agent also got sued. And the insurance ended up having to pay for it. So, got to be very careful. Question in the back.
Dumb question.
No dumb questions.
Okay. Instead of discriminating against the Section 8 tenant, could you argue you're discriminating against
Nope. It's very clever, but no. Do you know how you not take Section 8?
Rented.
Say again?
It's rented or rented to someone else.
Or just don't respond. Do you take Section 8? Block. Hi, I'm trying to text you. Block. Right?
Right.
You ever asked a girl out? Right? Does the girl have any obligation to actually tell you yes or no? She could just not pick up your phone. Right? She could just not respond to you. It doesn't matter if it's nice. Right? You don't want to get sued. Like, right? So when you want to say no to someone and you have any inkling that this might be a problem, ghost that person. I'm not joking. There is no law that says you have to tell them yes or no. Ghost them. Even if they start bothering you, right? Ghost them. Right? If they somehow get to a point where they get you or something, you say, "Oh, we're still looking at your application. Still being processed." Right? When you want to do something with the DRE and you send them an application, do they hop to it and do it in a week? No. We're still looking at your application 3 months later. You don't have to be any more efficient than the government is. Right? So we're still looking at your application. It's been 3 months. Wow, we're really bad at managing this property, aren't we? That's what you do.
I understand they're actually sending people physically to do this. In other words, going to rentals that are on the market to see if you're compliant with Section 8 or if you're turning people down.
So that's called disability testers, right? So what Michael is saying is sometimes they'll send people actually physically out there. They do that too. That's a different scam, right? So this scam is, they'll do this on purpose. They'll send 1 or 2 able-bodied people and they'll start asking questions about the second floor units and see what you say. If you tell them the price, if you give them a tour, blah, blah, blah. Then they'll send a couple disabled people and see if you tell them anything different, right? And if you tell the disabled person who's in a wheelchair that maybe the second floor unit in a building that has no elevator is not the right move for them, they will sue you. Or they'll bring a claim for discrimination, even though that makes no sense. And even though it was a sham, they didn't want to rent the apartment to begin with. And this is all completely legal, right? So you have to kind of suspend common sense when you are dealing in this city and in this state. And you just have to the best of your ability, follow the rules. But as I gave in my last example, don't be a sucker, right? Don't do more than what you have to do, right? Take advantage of the loopholes they leave. There is no rule that says you have to respond, so don't. In the back.
Two questions. One, you tell somebody that asks if you take Section 8 if you get caught, you can say fine, but wouldn't it be wise to say you have multiple offers? You don't have to take the Section 8 if you've got 7, 8 off, or
Yeah.
a couple or 2, right?
Sure, that's another thing you can do. If they say, do you take Section 8, right? Yes. And then block them.
Second question. If you're a mom-and-pop owner, who's actually instigating the filing of that harassment case? Like, if the tenant doesn't know much about harassment cases, and all you're doing is offering them keys, cash for keys,
Yeah.
who's going to some lawyer and getting you sued? Who's doing that? The tenant?
The tenant, a lot of the times,
Where are they getting their, reason for doing that? They're just reading up on things, or what?
they have a friend whose mom's cousin heard from her friend at the beauty salon that she got $50,000 because the landlord offered her money and she felt harassed. Right? And then they'll say, oh, this is what happened to, my mom's friend's cousin's thing at the beauty shop that I heard about. And they'll say, I want $50,000, right? Even if this is a tenant that you've been friends with for 5 years and you've had a great relationship and now you're just trying to do a nice settlement and send them on their way with some money in their pocket, they don't care about that, right? They want $50,000. So they'll be like, do you have that lawyer's information? And even if they say no, go Google after this, Los Angeles tenant lawyer, right? You'll see how many things come up, right? It's not that hard to find a lawyer who will take these cases now, unfortunately.
I'm surprised they're not advertising.
They are advertising online.
Like the,
On billboard advertising?
Yeah, like that.
Give it a minute. Any other questions? Yeah.
You can still charge 2 months deposit if you have less than 4 units, is that correct?
Yes, there are some it's less than 4 units. They have to be less than 2 buildings. Yeah. So yes, you can still charge 2 months. Go ahead.
I have a totally different question about non-conforming units.
Sure.
So if you have a building that's legally 4 units, a fourplex,
Yeah.
but you were able to carve out 2 extra non-conforming units, what kind of issues could you have with that?
Lots. A panoply of issues. Okay. What was your name?
Todd.
Todd. So what Todd is asking is, I have 4 units. I have a certificate of occupancy for 4 units. 2 of the units are quite voluminous. So I've decided to cut 2 of them and make 4. Now I have 6. Right?
Yep.
Okay. C of O says 4. I have actual 6. You have 2 units that are non-conforming is a land use term that basically means it was legal when it started and it got zoned around you and it got turned illegal after you already did what you did to it, right? That's kind of what non-conforming means. What you're describing is illegal, right? Those are illegal units. Number 1, you are not allowed to rent them. Your lease agreement is an illegal agreement because you are not allowed to rent a unit that does not have a certificate of occupancy. So all the rent that the tenant paid you, right, they're allowed to take back for going back up to 4 years, right? Also, let's say you say, all right, fine, it's illegal, but now you're living in an illegal unit. I want to evict you for that. You can't, right? That's not on the list of things you can evict someone for in LA. So the only way that you can evict that person, because they can't pay you rent, can't take their rent, you can't demand their rent, is you have to actually call LAHD on yourself. Have LAHD come, issue an order to tell you to stop using it for rental purposes. And then you're going to end up having to pay relocation fees to that tenant. Anywhere from $10,000 to $25,000, right? That's the only way you can actually get that person out, and it's a 60-day notice. And they're living rent-free the entire time. So don't do that. Yeah?
If the tenant didn't know anything about harassment laws, you gave them legitimate cash for keys, and then they hear this story about, you could have gotten 50, can they come back after the fact and say,
If you did a legitimate cash for keys, like let's say if you did it through my office, it means you got an agreement, there's a settlement agreement, there's a waiver of all claims, right?
that's the only way to really do it?
It also makes it, that's the safest way to do it. Whether the releases are binding might be a question because it's a public policy issue, it's a long story. But in that particular case, when you left, you took the money, you signed the agreement, it's really hard to then claim that the landlord was doing it in bad faith when you were doing it with him, right? So really that whole issue that I raised is when you're making offers that are rejected. When they accept the offer, there's really not a lot they can say, and they take the money. But when they reject the offer, that's when it can turn into an issue. How do you know if they're going to accept it or reject it before you make it? Right? That's the problem. Any other questions? Yeah, go ahead.
What is the differential between somebody that's about to be, 60 years and above as far as the buying them out of the
62.
62.
So what Michael is asking is about how much do you have to pay when you want to get rid of someone. So let me give you an example. It's probably going to be very relevant for some of you. Let's say one of your clients wants to purchase a regular old single-family home in the city of Los Angeles. That single-family home is owned by someone who was renting it to a tenant, right? The owner now wants to sell the house. Can they ask the tenant to leave because they want to sell the house? No, they cannot. That is the correct answer. Most people don't believe that that's the answer. They're like, what do you mean? I want to sell the house. I need to have it empty. I need to have it staged. That's not one of the reasons you have in the city of LA to evict someone anymore. Because remember, maybe I missed this point. In the city of LA, there's the rent control ordinance, which has a rent control and eviction control component to it. But they also have a just cause eviction ordinance, which is separate from that, and it applies to all the other rental housing stock that is not already covered by the rent control ordinance. Now, even though that just cause eviction ordinance doesn't talk about rent control, it doesn't talk about how much you can rent it for or price controls at all, it does talk about when you are allowed to evict somebody. And if it's not on that list, you cannot evict somebody, even from a single family home, right? So when you have a no-fault situation, which is, like, let's say you want to sell the house, you either have to buy the tenant out, and by the way, this is even after their month to month. It doesn't matter, right?
The lease is useless, right?
The lease is,
Essentially useless.
if you're talking about the expiration term in the lease, yes, the expiration term in the lease is useless.
How long they've been there, so in other words, if someone's been in a house for 12 months.
Yeah.
Then you can give them on the 11th month, 60-day notice to not renew the lease. That's what I was told. And also,
no.
if they're there beyond that.
What you're talking about,
Then it takes more time and it costs money to get them out. But I was always under the impression that if it's only a year lease and you give them a 60-day notice, you're not renewing the lease, and it's only a year.
no.
What are the rights of the tenant that has no lease?
Okay, so let's repeat the question. Let's say someone's only been there a year. They have a 1-year lease, single family home, okay?
In the city of LA.
City of LA, right? Can you, in the 11th month, right before the lease is about to expire, just tell them, I'm giving you notice right now that I don't want to renew your lease? The answer is no. You cannot do that anymore. Not since January of 23. That's what yeah. You can only evict them for one of the accepted reasons.
Okay, so now I want to get rid of them.
Now you want to get rid of them.
Buy a rental property ever if you can't do that. It's crazy. You can't, that's, wow.
That's kind of the problem.
When did that happen?
January 23. That's kind of the problem.
Good Lord.
Yeah. So how do you get rid of them? Well, you have a few options. When the buyer moves in, or when the buyer buys it and they want to move in, that's one of the reasons. If the buyer buys it and wants to move his family in, right? Family doesn't include siblings, doesn't include cousins, right? It's just children, grandchildren, parents, grandparents, spouse, right? So essentially 1 degree this way, 2 degrees up, 2 degrees down. That's
Buyer
it.
is buying it with the tenant in place.
Correct. So the buyer buys it with the tenant in place, right? They can move in. That's a reason. They can have one of those family members move in. That's a reason. Or if the seller wants to take the property off the marketplace, quote, permanently, then the seller can get rid of the tenant, right? Yeah. No one knows what permanently means, and it doesn't work like the Ellis Act. And when you do an Ellis, you have to record a memorandum. You record it on your property, and it makes it an Ellis property now. Everyone who buys it knows it, right? When you take the property off the market through the just cause eviction ordinance, there's no recording required. None of the other Ellis rules apply. You just have to file something with the city that says you took it off the market permanently. But no one knows what permanently means. Does that mean you can never rent it again for like the next 1,000 years? Nobody knows what that means.
They can't sell it either.
No, so what I tell my clients is very simple. If you want to stage your house because you know it's not gonna sell well with your dirty tenant in there, right? and you're there is for a little while, there's another option, which is called substantial renovation. So let's say you want to substantially renovate it. That means do some major work to the electrical, mechanical, plumbing, or structural systems. You theoretically, right now, you can use that as a basis, but the city of LA is trying to gut that out of the ordinance.
But even if
The
you
way it
take
used to be
advantage
in
of
the city of
these,
West Hollywood, by doing that, if you're done with your renovations in a year, that tenant has the right to come back. That's how it was in the city of West Hollywood.
Well, in the city of West Hollywood, substantial renovation doesn't even exist on the list.
No.
So that's only when you have to do renovations. That's a temporary relocation,
and I
right?
have these reasons that I can get rid of them, but I still have to pay to relocate them, correct?
Correct. So let's say you're the seller and you're doing either take it off the market, or let's say you're doing substantial remodel. You might have to pay relocation fees, and that's the question Michael was originally asking. How much do you have to pay? All right. If you own the house either in an LLC where you're the only owner, or all the people are all the owners, the members are individuals, and you own no more than 4 units plus this single family home, right? And the property that you're trying to evict someone from is a single family home, if you meet all those qualifications, then you only have to pay them 1 month's rent, right? Now, if you don't meet those qualifications, you still might be entitled to a discount, but you still, it's really only if it's not a single family home, then you still might be entitled to a discount. So for example, let's say you buy a duplex, right? The duplex is, say it's rent control, right? And you want to move yourself into the top and your kids into the bottom, right? You can still do that. You'll get a mom and pop discount if you are still complying with those other rules that we just said, right? If you don't comply with those rules, or if you don't qualify for those rules, I should say, then the amounts are like this. And these amounts change every July 1st. If they've been there for less than 3 years, then it's a little over $10,000.
This is the city of LA, right?
This is just city of LA. These numbers are different in every city, and how they calculate it is different in every city, because some of them depend on the room counts and some of them depend on the income. In city of LA, it works like this. If they've been there for less than 3 years and they are entitled but not qualified, and I'll explain what that means in a second, it's a little over $10,000. If they are qualified, they would have to meet one of the following elements. 1, there's a dependent minor living in the unit. 2, there's someone in the unit 62 years of age or older. Or 3, there's someone in the unit who's disabled, right? It doesn't have to be the main person on the lease. It doesn't have to be everybody. It could just be one person. It could be 70 people living in your unit, 1 disabled person. The entire unit is entitled to the higher amount, right? And then it's a little over $20,000. Same thing if they've been there over 3 years, then the amounts are, again, higher. Then it jumps to like $13,000 and a little over 25. Something like that, right? The mom and pop discounts are slight discounts off of those numbers, right? But that's pretty much what you're going to pay, is somewhere between 10 and a little over 25 if you don't qualify for the discounts.
So I only own one house.
Yeah,
I have no other properties.
yeah,
I have a tenant,
yeah,
right? I'm renting,
right,
okay? So I own a house that I've got a tenant in.
right.
I think it's gonna get me money. So now I wanna get rid of that tenant.
Yes.
All I have to do is pay him 1 month's rent? Good?
In your particular case, yes. If what you're renting is a single family home.
Betsy.
Yes.
Over here,
Betsy.
Betsy.
Many, number one, who do you pay that $25,000 to if there's multiple people in the house?
So it's one amount per unit. So they all split it.
Okay, so
Whoever's
it's
on
up
the
to
lease.
whoever's living there to make up their minds who's getting money?
No, they all split it.
Well, that might be fun. Anyway,
No, the way you do it is you pay the money to an escrow. An attorney can be the escrow. That's part of the service that we provide. You put the money with us. We send them escrow instructions and say whenever you want to turn in your keys, you come to our office and you pick up a check. And we know who's living there.
who's the check made out to?
Each of the individual tenants. Their pro rata portion. There are 4 of them. They get a quarter.
And the lease?
Okay,
No.
there's children involved, obviously. it's-
No, we don't pay the kids.
But it's just one payment to whoever's living in the house.
Yeah.
Okay, that's one question. Who would one call to find out, I have a tenant that needs to go out next May, and she's in West Hollywood.
Yeah.
And, how does my seller know if she did put any kind of cash for keys instead of her lease is up? How would she know how to find out how much money she legitimately has?
Yeah, you can go to the West Hollywood website. Just write West Hollywood relocation fees in Google.
Relocation fees, okay, and then the next question is, you were saying, take it off the market permanently. Is that to take it off the market to lease, or to sell, or
It's
just?
very good question. Sorry. It's take it off the rental market,
Okay.
right? Take it off the rental market. Obviously, you can sell it because that's the whole point of taking it off the rental market.
Oh, so you as an owner
Yeah.
sends this thing in and it's no more gonna be a rental,
Right.
because you're selling it to somebody.
Right.
And
But you have to-
A, you're okay with that, but B, if the new buyer comes in and they want to rent it,
That's a problem.
Okay.
You have to disclose to them that you've done this.
okay, thank you.
Yeah.
It's a recorded document, it gets recorded on title and it will show on the prelim.
It's not recorded.
It is recorded, I'm a title rep and I see them on the prelim.
What you're talking about are Ellis memorandums.
It's the notice to permanently remove property from rental housing market.
Correct.
The
That's an
title is-
Ellis memorandum. That's the memorandum that we do when we do an Ellis. An Ellis is only for rent control properties.
So when you remove a house like what she was just talking about, that doesn't get recorded?
There's nothing to record.
So when does that one get recorded? The one
Never.
that's all the time?
No, the Ellis. Okay, so let's clarify. There are two times you're going to take a property off the rental market. One is when you want to take a rent control property off the rental market.
Right.
That's what you're talking about. You have to do the whole Ellis procedure. The first step in an Ellis procedure is recording the memorandum. In the city of LA, it's called the E1 form. In everywhere else, it's just the form that's part of the packet, right? But that form has to be recorded on title. And that is how you tell the world, this is an Ellis property. This property got taken off the market. You can't rent it for the next 2 years, 5 years, whatever. There are different.
It says permanently on the document.
Theoretically, it's permanent, but it's not really permanent because you can take an Ellis property and start re-renting it after 5 years. Also, remember that half the time that people are taking properties off the market is to demolish the property. So when you demolish a rent control property because you Ellised it, right? Let's say I have a 2-unit building. I want to demolish it to build a 17-unit building. If I take that property off the rental market and then I rent those 2 units again, in the first 2 years, I'm going to get into a lot of trouble. The city can come after you, the tenants can come after you, and you cannot rent it for more than what you were renting for it before. If you rent it after the 2nd year, but before the 5th year, it's not quite as bad, but you still can't rent it for more than how much you were renting it before. And then after 5 years, then you have to tell the old tenants you can come back if you want to, but then you can rent it for market. That's after 5 years.
Assuming you can find it.
Assuming, exactly. It's another stupid rule, right? So what happens if you demolish those 2 units and build something brand new, right? And I'm going to give you an extreme fantastical example. Let's say I have Harry Potter magic. I have Ellised the 2-unit building, right? Everyone's out, and I use my Harry Potter magic to demolish the building and then construct a brand new one the next day, 1 day after everybody leaves. I can rent that building for market, right? It'll go under rent control, but I can rent that building for market day 1
Why would it go to rent?
because that's what the rules.
Wait, I built a brand new house, 2025,
Yeah,
because I'm Harry Potter.
Yeah.
And I bought it in 2024, and I have my new property in 2025.
the new property that goes up, the entire 17 units goes under rent control, unless you qualify for an exemption. And the way to get the exemption would be to give 20% or a 1-for-1, whichever is higher, to low income. Exactly.
If I'm taking a house off the market, let's say it's a duplex or a quad.
Yeah.
Right, for the purpose of destroying it and making single-family homes.
They
for
won't let you
sale-
do that anymore.
For sale.
They really won't let you do that anymore. But
Really?
if you want to build one single family home instead of a fourplex that's rent control, you're not going to pass SB 8. Yeah, they won't let you. There's a no net loss rule. So you can't really do that. And let's say you find a beautiful piece of property with a duplex on it, right? And it's mostly just empty land, right? They will not let you build one unit. You're gonna have to build 2 units, even if you want to use both of the units.
Is that a new law?
It's relatively new.
Okay.
Yeah. Yeah.
What are the tenants' rights for non-rent control?
For non-rent control. So there are, again, that really depends on what city we're in.
Long Beach.
Let's say Northridge.
Northridge is city of LA.
Yeah. So
Yeah.
Long Beach has no rent control.
Now, Long Beach, yeah, you're correct. It has no rent control. It does have a just cause eviction ordinance. When you want to do substantial remodel, you got to pay a tiny bit more because it's usually $4,500 regardless of how much the rent is. But mostly it follows AB 1482. AB 1482 is the state level rent control, right? That applies to all multifamily buildings, multifamilies 2 units or more. That'll apply to all multifamily buildings in the entire state of California if you're more than 15 years old. So if you happen to be in a building that's in Long Beach that is less than 15 years old, you are under no rent control whatsoever.
Tell your people to invest
What
in
is the
Long Beach.
maximum?
Yeah.
What is the maximum rent percentage?
Rent
that
increase.
a landlord can do on a non-rent control?
So again, depends on the city. Now here's
City of LA.
here's another fun little fact.
Is it like not more than 2% or something, or 2 or 3%?
No. So for that you're talking about rent control,
Yes.
right? So and then there's the state rent control, currently 8.9% in the city of LA. Question is, what if you have a single family home? Single family homes are not subject to local rent control. They are not subject to state rent control. They are exempt, right? You got to follow a couple little things and send them a little form if you want to exempt your single family home. But let's say you've done all that, right? What's the maximum rent? Is there rent control? Yes, there is. Say again?
10%.
No,
10.
it's 10%.
22%.
It's not 20. It's not 22%. It's not 4. It's 10. Michael, why is it 10?
I don't know why it's 10, but I asked you that question specifically a couple days ago.
No. So usury is interest. That is
So
that. Yeah.
If someone's charging
So-
22%, what is the tenant, what can the tenant do?
So hold on one second.
Of the rent.
Hold on one second. Hold on.
The previous rent?
No. Hold on. Let's explain. You have a tenant in a single family home, or let's just say a brand new apartment building. Okay? It is not subject to local rent control. It is not subject to state rent control. In the city of Los Angeles, why would you be subject to a 10% increase? Because there's another law, state law, called the price gouging statutes, Penal Code 396. And it says during the declaration of an emergency by the locality or the state or the feds, you are not allowed to raise the rent by more than 10%.
Because
Right.
they don't want you to piss them off to move out.
No, just because theoretically they don't want to have price gouging. Now, it's supposed to be something that it lasts for 30 days, 60 days, 90 days. Would you like to know how long the city of LA, has been in a perpetual, unbroken, consecutive state of emergency? 5 years is the right answer. 5 years we've been in a state of emergency. It was the fires and the floods and God knows what happened before COVID. Then there was all of COVID, and before COVID ended, they put in homelessness. And we've been in a homelessness state of emergency for 2 years.
But with COVID, wasn't it that I'm thinking of property taxes, forget
Yeah.
everything. Sorry.
So, theoretically, you really can't raise it more than 10% in the city of LA. Outside the city, single family home, let's just say we go to Burbank, right? Single family home in Burbank, raise it as much as you want.
City of LA condo, built in 79.
Condo 79 would be exempt from 1482 because it's condo, right? 79 would be exempt from LA rent control, so that would be 10%.
10%.
Yeah. Yeah, as long as this emergency is still in place, or until they fix this problem, right?
Can I give you what's going on?
Sure.
I have someone in Northridge
Yeah.
that has lived in a place for many years, 20 plus.
She's a renter.
Renter, non-rent control, obviously.
Yeah.
Place was fixer. Now they're fixing it.
It's a single-family home?
Condo, townhouse.
It's a condo, fine.
Townhouse. Now he raised the rent, raises rent 5% a year,
Yeah.
but right now because it's being remodeled, raised it another 22%
He did one raise of 22%?
total for the 1 year.
Yeah, he can't do that.
He can't do that.
Nope, not right now.
So what can she do?
She can tell him, I'm not paying this much because it's illegal.
But does she need representation?
Not for me.
Not from a lawyer?
No, she needs one, just not for me. I'm saying I only represent landlords. Yeah.
I have a question. So this is all so complicated, and I have people, clients and that sort of thing that want to know these things. And of course, we're not attorneys, so we really can't speak to it.
Yeah.
So if we want a client to talk to you, like, do you have like an hourly fee where they can have a
I do.
conversation? How does that work?
Yeah, so we do charge hourly fees. Unfortunately, I have to charge for my time. That's how I, put food on the table. So yeah, we do charge an hourly fee. I offer, people can just get on retainers. They can also just get like a 1 hour consultation. The current fee is $500. That's the 2024 rates. In 2025, that'll be higher. Probably something like $630 for me. But yeah, you can just call and schedule, and I can give them all the bad news.
You do fractions of an hour?
We do when it's on retainer, when it's like a, sort of a more permanent relationship or long-term relationship. When it's just a consultation, it's a minimum of 1 hour.
Just owners or tenants as well?
No, we do not represent tenants. Yes.
Why does that take?
No, lots of people represent tenants if they have a good claim against their landlord. Believe me.
They're hard to find.
For simple kind of things, yes, maybe. But there are people who will represent tenants if you have a good claim against your landlord. Yeah.
Hey, so one quick thing,
Yeah.
piggybacking on what you said, if you guys have a listing presentation with someone and they're saying, well, I'm either gonna sell or rent my house,
Don't rent.
I would encourage them to research what could happen, because they may never be able to get that person out of their house unless they pay them money to do so.
Right, and they may not know that. They may not be budgeting it in, right? Most mom and pop people or people who are just getting involved, they don't know these things. I mean, look, I'll tell you a case that was just like sort of heartbreaking to me. A couple buys a duplex thinking, okay, I'm going to move into the top, and then we're going to use the bottom unit also just for them, right? They're not landlords. They're in the marketing business. They have no intention or desire of being landlords, right? We go through the process. We serve their 60-day notice. Everything is all legit. The top unit is already vacant, so all they're trying to do is get rid of the bottom unit tenants. The bottom unit tenants go out and actually do hire landlords. And for some reason, I think they have a little money to pay an hourly rate people. They hire people who have no knowledge of these laws. And they say, what do you mean you want the top unit for you and the bottom unit for your spouse? You live with your spouse, so you have to stay in the same bedroom as your spouse. Your eviction is illegal. Now that's nonsense, because on the list of people you're allowed to get a unit for, it goes landlord, and then the second person after you as the landlord is spouse. It's not even at the end of the list, it's at the front of the list. And I explained that to their lawyers, and they're like, it just doesn't make any sense. I'm like, oh, thank you. Well, when I was writing this law, I didn't really think about that. I didn't write this. That's what it says, so that's what we're allowed to do. But they filed their own lawsuit against my clients. So we had to fight that lawsuit and still pay them and waive a bunch of their rent. It cost them a crap ton of money. And they're not even landlords. They're not even mom and pop landlords. They're just mom and pop, period. Right? They had no intention of doing this. They just bought a property wanting to live in it. Right? So you really have to be very, very careful when you are consulting your clients who want to do things like this, and if there's a tenant involved. As soon as there's a tenant involved and you're buying it, don't give any advice, right? Do not give any advice. All due respect, you're probably giving wrong advice. Yeah.
rent control,
So a single family is never going to be under rent control,
okay.
right? It's exempt from LA rent control. It's exempt from state rent control. The only reason there is a price, the only reason there is a limit on how much you can raise it, only in the city of LA, is because of this homelessness emergency, which triggers the price gouging statute.
Now, if you have a new ADU and it becomes a duplex,
Yeah.
how much could you raise for it?
So that's a very good question. Let's say you have a single family home. Now someone's built a duplex in the back. They're renting both units, right? The ADU is brand new, 2025 build. But the house is from 1946, right? The house is probably rent control. It's sitting on a 2-unit parcel. So that house right now would be 4%.
The 4%.
Yeah.
And now if you pay the utility, the electric and gas, is it?
Correct. You get an extra percent for the electric and an extra percent for the gas.
So that's 6 or it's total of 5?
Total 6. Yeah.
So if I,
Yeah.
so if I knock the houses down, right?
Yeah.
One house, knock it down, right? Build a brand new house with a brand new ADU.
Yeah.
Both are exempt, correct?
Both are exempt because they're both brand new. Yeah. But then you have to, you can't do the trick. You know, the trick they do when they leave up like 3 pieces of wood.
No, you can't,
Yeah.
part of the house, because they go back to 1943.
Exactly. So if you don't know what I'm talking about, there's an old trick to make sure that you don't get reassessed. And it affects how you can advertise the building, but it also affects reassessments. So a lot of the times what they'll do is they'll leave one wall of a house. And when I say one wall, I mean literally 7 pieces of wood. Okay, it's like the smallest wall they can find. It's like a closet. It's like this big, right? And it's just the 2x4s. And they'll say, "See, we left the wall. The whole rest of the house is just a remodel," right? It's literally a brand new house. The reason they do this is to avoid the reassessment, right? But then, if you're doing that, you can't advertise it as a 2025 build. Now you have to advertise it as whatever it was before, because you can't have it both ways, right? So then if you rent that house, you can't have it both ways, because you're not going to get a new C of O. In order to get out of rent control, you have to have a C of O. It's after 78, right? So can't have your cake and eat it too. Go.
Just last question, I think Michael before was saying if you have an R2 zoning,
Yeah.
which is for duplex, right? Okay, and then you demolish that and you build just one brand new home. Is that, and you wanna rent it?
It's probably, I mean, theoretically, if it wasn't a rent control duplex, and depending on the income of who used to live there, maybe they'll let you do that. It's sort of a rare situation here in LA.
They do that, the developers on an R2, they don't have the dimensionization, and they can build more square footage. If it's an
They
R2.
do it in
as
Venice, or
compared to
they have
R1.
been doing Venice
So I
a
think
lot.
that's what he was,
What, building the single family homes?
On R2s, yeah.
Yeah, I know, but
But
that's
they're still zoned as R2.
the zoning is irrelevant. You can build on an R2 anything you can build in an R1. You can build in an R3 anything you can build in an R2 or R1, right? And so on. So the zoning is really not relevant. If you could demolish a duplex and build a brand new single family home, it's a single family home, right? And if it's a 2025 build and you don't do the little wall trick, then you're not going to be subject to any rent control, again, unless you're in the city of LA, and then you still have the emergency situation. By the way, when the emergency is over, or when they fix this problem, because the reason they did the homelessness emergency is not to trigger the price gouging statute, right? My suspicion is that there are people in the city who don't know they did that. The reason they do that is because when there's a local emergency, the mayor has a lot more power to move around money and do stuff on her own without getting approval. That's why they pass emergencies, right? But they don't know they also triggered this other big problem, right? So they can have the emergency without triggering it, or when they just get rid of the emergency, then single family homes will have no rent control limits in the city of LA. Yeah.
one last question, okay, if the tenant dies,
Yeah.
terminates the lease, right?
It does 30 days later, yeah.
Okay, now, if that tenant had a roommate slash guest, that's not on the, was not on the lease,
Depends on if you knew about the roommate. It depends on if you took rent from the roommate. It depends.
No rent.
You weren't taking rent from the roommate. Did you know about the roommate?
I knew, hypothetically, let's
Yeah.
say I knew about it, but the landlord also knew about it,
Yeah.
but didn't do anything about
The
it.
landlord didn't do anything about it and knew that the person was there.
But it's not on the,
It doesn't matter really if it's on the lease. That person may have a claim. You might be able to claim that that person's an unauthorized subtenant and get rid of them that way. It also depends on if they were paying rent. It's very, very fact dependent. Also depends on which judge you get sent to.
but it's
It's
an eviction, but it's an eviction.
yeah, you're gonna have to do an eviction, but whether or not you win that eviction is very much unique to the circumstances. Yeah. Are we?
Thank you, ma'am.
Okay, that's all my time. So I'll stick around for a couple minutes and got some cards if anybody wants to call. Thanks, everybody.